Good afternoon, everyone, and welcome to the Law 2021 Online Family Law Shape the Debate, sponsored by our Family Wizard, with me, James Evans, and Safta Mahmood. In this live session, you can put your questions to Safta and interact as the information is being delivered. Today's live Q&A is due to last 1 hour, and we will cover all your pre-submitted and live questions. To the right-hand side, there is a chat function. All questions are submitted in private, so please ask away. If you're watching a replay, the live chat function is disabled, but you may contact the solicitors group for further information. A recording of today's live session will be sent out by email within the next few days, so please do keep an eye out for this. As I said, my name is James Evans. I am a professional liaison for our Family Wizard. My role includes educating judges, barristers, solicitors, and all other family law practitioners about the online tools that can be utilised to benefit and monitor parental communication in high conflict cases. I travel the country attending family law conferences, workshops, and seminars every year. And before I worked with our Family Wizard, I was a teacher for about 4 or 5 years too. Our Family Wizard offers divorced or separated parents a collection of web and mobile application-based tools to easily schedule parental responsibility, share important family information, manage expenses, and create an accurate, clear record of co-parenting communication. Working with parents on our Family Wizard, family law and mental health professionals can leverage its tools to oversee communication and facilitate successful parenting through family separation and divorce. Our Family Wizard is recommended regularly by family law and mental health professionals and courts and judiciary in the UK, throughout the US and Canada, as well as Australia and New Zealand. It is my pleasure as well to introduce you today to Safta Mahmood. Safta has extensive experience in both practicing and teaching family and children law for over 27 years. Safta practices predominantly in children law proceedings alongside his lecturing and legal writing. He has been a continuous member of the Law Society Children Law Accredited Scheme for approximately 20 years and is both an ambassador and an author, having written in various legal publications, including for the Law Society. He is a highly articulate and popular speaker who has a practical and pragmatic approach to his subject. As part of the Law 2021 Online, Safta sessions include private law children cases, where are we now, enforcement of child arrangements, what options are available, and children cases, fact-finding hearings, and domestic abuse, current judicial approaches. So to kick things off, we will start by addressing some of the pre-submitted questions we have been receiving from you. And Safta, the first question I'm going to ask you today is on the Children Act. What is the difference between Section 7 and Section 37 of that Children Act from 1989?
Fantastic. Well, thank you very much indeed, James. Thank you for inviting me today and for that fantastic introduction. Thank you very much. So yes, let me kick off then with answering this question. And it's one that you'll find we as practitioners do sometimes get confused on in terms of then delays that will be caused and sometimes uncertainty as to whether the report actually covers what should and should not be contained within the report. So putting it simply, let me give you an example. Let's say I'm acting for the father. He instructs me to apply for an order for child arrangement, spending time with or otherwise having contact with, as you know, what we used to call the old contact orders all those years ago. And so we lodge our application. We get to court. Let's say it's the mother who's the opponent and she's opposing father's application. Now, this is where the judge, of course, is going to need the benefit of fact and evidence-based information to be able to make an informed decision on. And that's where the Section 7 report comes in, Section 7 of the Children Act, where ordinarily it'll be the CAFCAS officer, CAFCAS Cumbria and Wales, or sometimes social workers if they've been involved with the family for a decent period of time, you find. They may well be directed then to do the Section 7. And what it does, it pulls together the information under welfare principles under Section 1, principally Section 1, subsection 3 of the Children Act in terms of the welfare checklist. The report typically takes about 12 weeks. A lot of it's contained within the Child Arrangements Programme Practice Direction 12B. Now, how is that different to a Section 37? Well, taking that example further, let's say father is seeking not just spending time with, otherwise having contact with. He's in fact suggesting that the child should in fact be living with him, what we used to call child arrangements order. We used to call residence order rather. Now, if he's raising child protection issues, he's saying that mother's in this new relationship with another chap or lady where they are a risk to mother, and in turn there may well be a risk to the children of maybe sexual abuse, physical abuse, or other forms of abuse, then that's where if a judge is satisfied that the threshold are met for the purposes of Section 31 of the Children Act, then that's where they can direct the local authority to carry out an investigation to see what the risks are, what safeguards can put into place, and more significantly to see what they can do and what they should be doing in looking to commence any care proceedings or supervision order application. And that investigation is basically the Section 37. It takes about 8 weeks to do, and the local authority can even be granted an interim care order under the auspices of that, just to enable them to carry out the necessary investigations and inquiries. So both of these, they are similar, but as you can see, very different functions that will be used then in the private law context.
That's really helpful, Safta. Thank you. I think that knowing those differences is crucial, particularly with proceedings these days. So following from that, what would you say is the likelihood of a court switching living with arrangements as a method of enforcement?
Thank you. Well, what you'll find is, as I often say to clients, there is no one size that fits really. And what you'll find is and let's change the facts around. Let's say this time around it's the father with whom the children are living with, and say you've got mother who's saying to you, look, I've got a child arrangement order specifying spending time with, otherwise I'm in contact with, and despite my best effort, father's not abiding by that. Every time I go and pick up the children as per my contact arrangements, he's making excuses. He's saying, look, they're not well, they don't want to see you, I've got the dates mixed up, and so forth. So she's getting fed up, and she's then thinking, well, look, what do I do in that situation to enforce the arrangements? Now, like I say, there's no one size that fits, and in the main session that I did, you will have seen that there's various options available. One of those is switching living arrangements, switching residence, as we used to call it. What's the likelihood of a court switching living with arrangements? Well, what I would say to you is this. Over the last 2-3 years in particular, there's been an evolution of case law surrounding parental alienation. Now, this is a concept that's been around for years, in fact, but over the last 2-3 years, more and more senior judges are making more initiatives, making more coverage and providing more coverage insofar as the concept of parental alienation. There's that case of Re-H, for example, the 2019 decision by Mr. Justice Kean, where in that case, I appreciate it was 6 sets of proceedings that had been run in that case, but the father successfully was able to apply for switching of living arrangements in his favour relating to his 12-year-old child. Now, this is a child who had been living with his mother, for the young age that he was only 12. He was living in one part of the country, father lived in another. Living with arrangements would mean new school, new friends, new clubs, new environment, living with his father rather than his mother. But the judge balanced that and thought, well, if I don't allow this is then the effect of parental alienation. This child is going to be affected both in the short and the long term. This can lead to depression later on in his life. This can lead to this child missing out on that significant relationship with his paternal family. Not just now, but indeed in the future. There's also the more recent case of A and B, number 1 and number 2 that I've referred to, where the experts in that case specifically drew out the fact that parental alienation can even be intergenerational. So it's not just going to be affecting those children, it can affect any children that they have as well in the future, and it can even lead to depression later on in life. So I suppose when you look at that, I would say that given the way in which the legislation and the case law has developed over the last few years in particular, I would say that there is a greater likelihood of judges switching living with arrangements if necessary. And I think it always comes down to, does it and will it meet the child's best interest? It's always coming down to that, as you know, and therefore if it will serve the child's welfare best interests, then there is that possibility they'll do it.
And that has to be the focus, always, the child's best interest. That's often cited as the reference. And I know that parental alienation has been a contested phrase over the last couple of years. It's not necessarily been defined, which I think is why it's contested by the courts and the superior authorities. So what is the position with the definition of, we can talk about domestic abuse and whether parental alienation fits into that category of domestic abuse.
Yeah.
Do you have a definition for parental alienation, or is it more relevant to ask what the position of the definition of domestic abuse fits into with the new Domestic Abuse Act from this year?
Sure. Yeah. Okay. No, that's really good. And in fact, what you'll find is like anything that happens in the way in which we run these cases, terminology changes, the way in which so for example, many of us will be familiar with residence orders, contact orders. I mean, when I first started almost 30 years ago, before the Children Act, we used to have access orders and custody orders. Of course, those then changed, became residence, became contact. Now we've got child arrangements living with, and I suppose and spending time with. And I suppose it's the same with parental alienation. I remember years ago we used to use the terms implacable hostility, intractable contact disputes, and parental alienation isn't a new feature. I'm thinking back of a case called Re S back in 2010 by His Honour Judge Bellamy, for example, which was a very tragic case involving a 12-year-old who sadly was switched to live with his father, but he almost had a nervous breakdown, and that was a case where it didn't work. But again, in that case, over 10 years ago now, in 2010, the judge referred to parental alienation in that case. So I suppose, what do I understand as a definition of it? It's as many of these cases have demonstrated, it's where a parent is subjecting a child to a level of coaching, priming the child, almost giving them very negative vibes and views about the non-resident parent, which is almost changing their opinion, their view about that other parent. Sadly, in many cases, a very firm opinion, but an untrue opinion of the other parent. And that then is affecting that child's kind of mindset insofar as them having more
alienation from one parent created by the other.
Absolutely. So it's this idea of being primed, coached into having these very negative views of the other parent. And sadly, that then manifests itself into that child then beginning to believe that those negative views are actually true. And that's what then causes that child not wanting to see the parent in those circumstances. And that's where sometimes you'll find this is where there's the use of Rule 16.4 of the Family Procedure Rules, and that's where we join children as parties within these proceedings. But even that, I would suggest, is something that needs to be tread very carefully, because if you join this child, which means you don't have a guardian for them or a solicitor, then even though that child then has their own voice, the problem is whose wishes and feelings have been put to the court. If that child has been primed, is it that child's independent views, or is it the views of what their parent has coached them on? And that's where I think judges have to be very careful about even the use of 16.4 in that regard. But to go back to your question, which was also in terms of domestic abuse. Well, domestic abuse under the Domestic Abuse Act is the first statutory attempt which we've had, where finally we've actually got the first ever statutory definition of domestic abuse. It's been around, in terms of the definitions. CAFCAS had their own definition, the court had its own definition, Practice Direction 12J, the Legal Aid Agency had their own definition, but this is the first attempt at trying to bring a unified definition across all agencies. And effectively, Section 1 of the Act says this: domestic abuse now, as of when this came in, which was across many Acts of Parliament on the 1st of October this year, is this: it's abuse between A and B. So it's behaviour between A and B, where A and B, both of them have to be 16 or over, and they both need to be what's called personally connected, and the behaviour has to be abusive in nature, and the abusive nature incorporates, amongst other things, sexual abuse, physical abuse, neglect, emotional harm, coercive, controlling behaviour, but it also incorporates specifically economic abuse. And I think that's the new one, because that's something which we did have in the elements of coercive and controlling behaviour, but they've now almost put it as a separate one altogether. And I think that, I would suggest, is perhaps one of the key differences between what we've got now and what we had previously.
Yeah, it's interesting, and I know there's such a huge focus on language at the moment in family law. It's something that the president spoke to in his address at the LBA, that the focus on language and the definitions on some of these terminologies and phrases, both in terms of practice from legal professionals and in the media. There's a new project ongoing at the moment called the Family Law Language Project, headed up by Emma Nash and Gemma Hope, and that's really interesting. I'm really interested to see their work next year, to see how they will nail down into the terminology of some of these phrases, both from a legal perspective for practitioners and from a media perspective, because the media are using outdated terminology, but we in the practice are using more up to date. So it'll be interesting to see how that works. We do have a live question that's come through, Safta, and it's in relation to the Rule 16.4. Hopefully, a Rule 16.4 guardian will be experienced enough to see the nuances within a child's expressed wishes and feelings. But in your experience, do they have sufficient understanding of parental alienation?
Thank you very much indeed for that question. I would say yes. I would say yes, because even though the concept of parental alienation has been a concept that's been used and referred to as we say, going back over 10 years, I would say that a lot of the guardians, CAFCAS officers who are coming through, some who are obviously a lot more experienced than others, I would say a lot of their training is now, and I know of many of them in terms of the training, a lot of them are being trained up to have a much greater understanding of not just parental alienation, but also other forms of behaviour, which then, of course, impact on the way in which the parent is meeting and purporting to meet that child's needs. So I suppose what I would say to you is, and this is where in the main session that I provided is the case of A and B parental alienation numbers 1, 2, 3, and 4. So it's an ongoing case, and in that particular case, it's one where the mother did seek to invite Mr. Justice Kean to allow a 16.4 guardian, but the problem was she left it very late in the day. It was almost very late in the sets of proceedings where there had already been a finding of parental alienation. The proceedings had been ongoing for some time, and the view the judge took was, if I now give you that 16.4 direction, well, because I've already got evidence, and which is quite firm evidence of parental alienation, any views that the child does express, even to a very experienced guardian, well, one, they're going to be dragged into the proceedings, which I don't want, because that's going to cause the child potential further difficulties in being drawn into this, which really we want to try and avoid. But secondly, how much weight am I going to actually attach to that child's wishes and feelings, bearing in mind you are ascertaining their wishes and feelings to the prism of effectively parental alienation. So I suppose to answer the question, would a guardian have sufficient experience and understanding of parental alienation? I would say yes. I would say yes to that.
Good, yeah, and I think that's the way we have to approach these cases, in the hope that they have the experience and that the focus is brought back on the child, which is the absolute crucial element.
Yes.
So moving on slightly to public law now, and what kind of orders for personal protective injunctions can be made in public children law cases?
Sure, thank you. Okay, so in public law, you'll find, and when we're looking at public law, we're looking at where local authorities then will then intervene. So you're looking at emergency protection orders, you're looking at interim care orders, placement orders, and so forth. And I think sometimes family practitioners perhaps fully don't appreciate the fact that actually there's a lot of availability even in public law proceedings for personal protection orders. So, for example, many of us who do non-molestation occupation orders will be used to pursuing those as a freestanding application. Say, father, for example, comes to you, he's the victim of abuse and against his partner, and he needs the benefit of a non-molo occupation order as a freestanding. But actually, many lawyers are unaware of the fact that if you look at, for example, Section 44, subparagraph 2, subparagraph B of the Family Law Act of 96, you can even get a non-molestation order made within public law proceedings. So if you've got a local authority involved, for example, the local authority, the guardian, some other party within the proceedings can even ask for non-mole within those proceedings to actually protect the child in those circumstances. So those are available within family proceedings, which care proceedings are. But then there's also specific orders you can go for in public law. There's orders under Section 38A, for example, of the Children Act, which is you can get an exclusion order attached alongside an interim care order. So that's available. And you can get the same exclusion provision attached to an emergency protection order, an emergency protection order in that regard. So what you'll find is there are specific public law protection orders. I've been involved in cases where we've had what's called CSE orders, child sexual exploitation orders, which are then made to particularly protect children and vulnerable adults who have been sexually exploited by adults, and that's where you're then going against the individuals concerned to be able to get those CSE orders. So there's a lot available in the public law arena as well.
Good. Yeah, that should be the case, especially with the last couple of years we've had with lockdown and COVID and things changing. So in that vein, what guidance is provided in case law as to the position with children having COVID-19 vaccine when there are disputes between parents and also when the local authorities are involved?
Okay, thank you. Now, two things really. One is, as you say, James, because of the lockdowns, the first lockdown, it seems like a long time ago now, doesn't it? But March 2020. Yeah. And earlier that year, in fact, it was January 2020, we had the Stalking Protection Act, for example, of 2019, which came into effect. So I don't think anybody appreciated, perhaps, when that act came in January 2020, that actually it was going to be used as much as it has been. It's a kind of civil order. It's the police who are pursuing that. And actually, looking at some of the statistics on that has been used a lot in the last year and a half, sadly, because of the restrictions that we've all had imposed upon us, and people have been exploring other ways to stalk other people. So that's been used. But in terms of guidance given in relation to children having a COVID vaccination, this is where two things really. One is if you've got a situation whereby you've got a dispute between parents. Then there was a case, M&B, which was the case back in December last year, December 2020, whereby the court in that case said, I think it was handed down on the 15th of December last year, whereby the court at that stage said that if we do get a vaccine, which is going to be available for protecting children against the COVID virus in the future. Obviously, 15th of December last year was just 2 weeks after the AstraZeneca vaccine became available. Then the judge, Mr. Justin McDonald, did say that if one did become available, then in the absence of any peer-reviewed research, any medical evidence to suggest otherwise, to show that it has a drastic, significant impact on children's welfare, it's likely that we as a court will actually be authorising it, because it'd be wrong for us to say otherwise. And that was as early as 15th of December last year. There has been more recent authority. There's the Reese case of September this year, which was a care case about a child who was subject to a care order and looked after a child. And that's one whereby the child, who was 12 years of age, he wanted to have the COVID vaccination and the winter flu vaccinations. And as you'll be aware, the COVID vaccination had become available for children between 12 to 15 from, I think it was the 4th of September it became available, if I remember. So he wanted that. He was consenting, although the question mark as to whether he was competent or not, whether he was Gillick competent. His father was saying fine. His mother was very much opposed to the vaccine, and a local authority took the view that actually it should be ordered, as did the Guardian. Now, the question in that case was, does a local authority, in the exercise of their parental responsibility via an interim care order or care order, can they use Section 33, subsection 3 of the Children Act to say, yes, the child is going to have this as long as you inform the parents? They weren't sure, and I think they did the right thing by taking that to court. And in fact, the court on that case, it was a High Court judge, Mr. Justice Peel, who took the view that, in fact, in that case, the court can, in those circumstances, authorise the vaccination as long as it is in the child's best interests and it was felt that it was necessary in the circumstances. And one of the things the local authority needs to satisfy the court is it needed? So it's back to the best interest argument again that you mentioned. And because a lot of the evidence from chief medical officers was children should be having this to obviously protect them and other parties as well, then that's where your evidence is really then suggesting that that they should be having that. So that's the public law case on that. But like I said, the private law case on that was the case of M&H private vaccination, which was the one of December last year by Mr. Justice MacDonald. So I would say, and I know there's controversy on this, but I would say at the moment the case law as it is very much supportive of these vaccinations as the medical evidence stands.
I think that's good. I think it's important that we see our senior judiciary aligning with our government as a person, as a body, as a public. They're senior authority figures. I think to see them aligning on this kind of thing is going to be important as a message, both in court and everyday life. So that's really positive to hear. Just a reminder to those listening, if you do want to ask Safta a question as we go along, you can use that Q&A feature on the right there, and we'll ask them as we go. So moving on to our next question, Safta. What is the purpose of an appointment of a children's guardian and joinder under Rule 16.4?
Okay, so that question, I suppose we've looked at in terms of in the context of the Section 7s and 37s and Parental Alienation. So as I mentioned earlier, this is where in private children law cases you'll have situations where it's felt by maybe the guardian or any of the other parties or even the judge that that child needs to be joined as a party to the proceedings. And what I would suggest is when any of yourselves have cases where you're looking at joinder, look at paragraph 7.2, because that gives you the different categories of when children may be joined. And the one I've often used is subparagraph C, which the one where you're saying that any form of spending time with, contact as we used to call it, has come to an end, it's ended altogether, or it's very minimal, or there is such level of intractable hostility, and that's where you may find that joinder is appropriate in those circumstances. And the benefit of the child being joined is they then have their own representation, as we said, and that's where they'll have their own guardian and often a solicitor as well. So they'll have their own voice, which they can then, of course, put to the court in that regard.
That's helpful. Thank you.
Okay.
And we've talked a lot about, the children and how important it is for us to hear the voice of the child and have them, their thoughts and feelings be prioritised. What is your view as to the guidelines, what the guidelines are to encourage judges to meet with children involved with proceedings?
Okay, so what you'll find then is, these guidelines are back in April 2010, in fact, so they've been around now for some 11 years. And I think they're fantastic. I think those guidelines are so encouraging because they encourage judges in children cases, in family proceedings generally, to ask themselves a question as to whether it's actually beneficial for the judge to meet with the child in appropriate cases. And the lawyers, the social worker, the guardian, CAFCAS officer, any of us can then suggest to the judge in appropriate cases that this may be one where it would be beneficial for the child to actually meet with the judge. But what's important with the guidelines, and this is where paragraph 5, paragraph 6 of the guidance in particular says that when and if the judge does decide to meet the child, they mustn't see the child alone, because of course then it mustn't be any suggestion that the child may have said something which the judge didn't maybe document, or the judge didn't in any way entice the child into saying something, or didn't in any way persuade them to take a particular view. So they mustn't see them alone. There should always be somebody there, and in practice you'll find it'll be either the lawyer and or the CAFCAS officer or social worker who will be there. Many judges will almost have a little script that they prepared where they will read out and say, right, this is my role, this is what I do, this is what I'm going to be talking to you about. But the important thing about the guidance, over and above the practicalities of it, is what does it achieve? And what it achieves is the ability of the child to be able to feel that they've been heard. It's the ability of them to feel that the judge has heard them. The judge has explained to them the procedure, what the judge's role is, what the role of all the other professionals are. And the judge enables the child to feel hopefully more confident in the procedure, that their views have been weighed up, taken into account, considered, in enabling the judge to make an informed decision. But one of the important things the judge has to bear in mind is when they do speak to the child, they do need to make it very clear to them that they're not going to go with just necessarily what the child is saying. They'll weigh up, obviously, what the child is saying. They'll weigh it up amongst the other factors, and then enabling then an informed decision to be made. So actually, as a concept, and the way it's been used over the last 11 years in both private and public law proceedings, I would say is fantastic, and it's to be recommended.
I agree, and as we keep saying, with the focus being on the child, to give the judge that extra level of understanding is so important. It must be so hard for the judges to try and decipher what the child's views are, because if there is a case where we've discussed, like where there's parental alienation and that child is passing on the views of the alienating parent, the judge has to be the one that deciphers whether that is the view of the child, the view of the parent, and what's been learned to them. Do you think that must be quite a challenge for them?
It is, and in fact, what you'll find is sometimes, I remember some years ago, we used to even have cases where we used to have experts who were instructed to do these what's called veracity assessments, where we used to sometimes have an expert who was given a copy of the child's interview, for example, and then we're asking the expert to give us a view as to whether they feel, based on the child's body language, what they say, the intonation in their voice, whether they felt that the child was telling the truth or whether they were coached and primed. And those kind of assessments were short-lived, because in fact now the courts are saying, hang on a minute, that's a judge's role, that's what the what judge is there for, and therefore it is a big responsibility for the judge, because he or she has to listen to the child, take on account what they're saying, listen to everybody else, weigh up obviously, and then they've got to decide for themselves, what weight do I attach to the child's wishes and feelings here. And that's a difficult one. Very, very difficult indeed.
At what point in the proceedings would they have that conversation with the child? Is it something they would have at the start, something they would have at the end, halfway through?
It does vary. It does vary. My experience has been it tends to be more so about kind of mid-range, really. So it's the case whereby you're in proceedings. You've had your FHEDRA, you've had your maybe Section 7 report that's been filed, and now maybe the judge is thinking, well, actually, mum's saying this view, dad's taking this view, guardian is saying this, child does have 16.4, child is joined. I want to see them, because it's an older child who seems to be having a different view to what the mum and dad want, and I want to see the child so that I can hopefully reassure them that actually I will take on board their views and I will weigh that up. So I've tended to find it tends to be more kind of mid-range, those cases. But one of the things the guidance does say, and this is where some judges have been challenged on this, albeit they've managed to avoid the appeal. There was a case of NA, for example, whereby the High Court judge in that case was challenged by the father for being too robust in terms of asking the child too many questions to try and almost gain the child's wishes and feelings. And because the guidance does say that the judge's role isn't to interview the child in the same way as CAFCAS and the social workers, that's their role. It's more to help the child to get an understanding. But what that case of NA illustrates is a child that the judge is allowed to almost take a view of being able to get a good understanding of where the child is coming from, but without being direct, rather than saying, who do you want to live with? It's more, what do you enjoy about when you spend time with your mother or your father? So it's almost asking questions in an indirect way in that regard.
Sure. I mean, the context must be so important for that judge to ask those questions. As I said, I was a teacher. Sometimes a child is lying and they don't even know they're lying, because of their learned behavior. So I think the context of where those conversations are coming as part of that ongoing proceedings are so important. We've had another question, live question come through, Safta, in relation to this, and they've asked that, do you think district judges, as opposed to circuit judges, have sufficient insight into the wishes and feelings if there is a suggestion of parental alienation?
Yes, I would say they do, and I would go as far as saying that judicial training now is very different to what it was I would say 10 to 15 years ago, because the way in which this area has developed, I mean, nobody would have thought that we would have been in this situation from early part of last year, where we would be having these remote hearings, and we would be having hearings in plentiful supply remotely, where a lot of challenges have been thrown upon us. And in the same way, I would suggest that when you're looking at concepts such as parental alienation and the way it's been developed over the years, and a lot of the leading authorities just in the last 12 months, I would say that a lot of judicial training for judges across the board, and not just district judges, that goes far saying magistrates, lay judicial officers and legal advisors, they're being trained up a lot more on trying to recognize that this is a concept which is there, and it's a concept which does need exploration and consideration. So yes, I would be confident in saying that they do have a very good insight into those elements.
It's clearly a hot topic and something that we will continue to evaluate over the coming years, and it'll be interesting to see how parental alienation becomes more defined, more trained, more educated amongst the judiciary and other practitioners. Coming back to some of our pre-submitted questions, this one I think you've touched on this slightly, but I'll ask it just in case there's more you want to divulge into. What are the aspects of the revised Part 37 FPR 2010 in terms of committal?
Okay, so this is part 37 of the FPR, which is that which relates then to committal applications across family proceedings. Now, this was a kind of newish addition to the family procedure rules, because when they first came in, there was 36 parts, and this was one of the new ones that came in a few years ago. But what's different now is this: the Part 37 changed on the 1st of October last year, 2020. It's a lot more streamlined. It's a lot more in line with the CPR. But the one thing many of you will find with the revised Part 37 is, and I'm really excited about this, we've finally got a form, because for years I've been saying, which form do we use? Is it an N78? Is it a D11? Is it a Part 18? Is it a C2? What do we fill in? Because there's been a lot of uncertainty. Finally, we've got a form, and there was a new form that came in called FC600. It only became available on the 30th of July this year, so it's still quite new, but it's great. And if you look at that form, and some of you who will have had a chance to fill it in, it's brilliant because it actually literally goes through all the elements of Part 37. One of the interesting things I like about the form and the procedure for Part 37 is this. Say I'm for, say, the mother, and the mother is saying, look, father had given an undertaking that he won't do certain things as per the non-molestation order, for example, and he's breached the undertaking. What she needs to certify on the Part 37, the FC600 form, is she needs to set out how she believed that her ex-partner understood what the undertaking was and what it meant for him, so to speak. So it almost kind of puts her in the equation as well, for her to be able to certify to court why she believes that he understood the terms of the undertaking, or the order, as the case may be. So in that respect, I like the new procedure because it's a lot more streamlined. It's also in line with COVID. It allows the courts to deal with these applications in private if they need to. They don't have to have public hearings. Obviously, we haven't got as many now because of COVID, and also because of the risk of contamination. The applications don't necessarily have to be personally served either. So they are big advantages there in that regard as well. So yeah, I think it's definitely going the right way with Part 37.
Anything to help streamline the process, I think, is a good thing.
Absolutely.
And you touched on COVID a couple of times there. The next question is, what guidance has been provided by the president of the family division surrounding contact and spend time with arrangements during the pandemic?
Sure. Okay. So this relates to the guidance which was issued very soon after the first lockdown that we had back in March 2020. And the president, Sir Andrew McFarlane, he was very quick off the mark because he could see that this was becoming an issue. And some of you may remember there was a lot of inconsistency when the first lockdown was announced. There was concern that certain politicians were taking a view that actually if you had, say, a shared child arrangements, living with order, or even a living with order which said children are living with mother and dads to be having contact on certain days, because of the only 4 reasons why you could leave your home under the stay-at-home rules in March 2020. What the message was that was being given to people is, well, if that means that the child's living with mother, for example, unfortunately, that would mean that father misses out on his contact. And you can imagine, the uproar and the upset and the anxiety parents had. So quite rightly, the president had to step in and deal with this, and he did. And of course, that guidance, which is still valid today about child arrangements and COVID, one of the things his lordship has said in there is that parental responsibility rests with the parents. So, as judges, they can only obviously give guidance in that regard. There is that limit to what they can and cannot do in these circumstances. And if it's safe to do so and appropriate to do so, then parents can between themselves temporarily vary the arrangements. But then if they do, then they've got to be looked into to see what other opportunities they offer for contact, whether it's indirect or otherwise. But one of the key bits in that guidance, which I find really helpful, is this. What if you've got mother, for example, assuming that the child's living with her, and she takes the view that actually it's unsafe for her child to go and spend time with, say, the father, because say he's living with his family where there may be a risk of maybe contamination from the child to his family or vice versa. What the guidance says is the mother can unilaterally vary the contact in that situation, but to avoid her abusing and exploiting that privilege, she needs to make sure that she does two things. One, she needs to make sure that she puts in place alternative forms of contact, whether that's, say, FaceTime, Skype, WhatsApp contact if appropriate, or other forms of social media contact if appropriate, if it's safe and necessary to do so. But secondly, if she's challenged by the court and indeed by father at a later stage to justify her position, she needs to be able to do so. And I know many practitioners, when we had the first lockdown, many practitioners were relying very heavily on that guidance to try and ensure that contact was maintained. But it's still good guidance today, because of course we're still not out the woods, nowhere near really, and we don't know what's going to happen moving into 2022.
No, of course. And of course, after there are the best ways of these parents to communicate is through our family wizard, of course.
Of course.
During that separation process. So what does it mean to make a child available for contact?
Sure. Now that's a really interesting question, because what you'll find is the word available has been, subject to so much debate over the years. So going back some years now, there was a case of LW, for example, the 2010 decision, where in that case, the Court of Appeal took the view that to make available is just that. It's to make a child at your disposal. So in that case, it was a 10-year-old who was living with father. Mother used to drive to dad's home to pick up the child, except the father used to say, look, I'm really sorry, but he doesn't want to go with you. Mother used to walk away, obviously really upset, and she went for enforcement orders and unpaid work. But the court in that case said to make available is just that, to make at your disposal, not to compel and not to insist on, but to make sure, for example, you don't set anything else up for that child to do that day, and therefore you, for example, you pack their bags and you make them available to spend time with the other parent. But if the child is saying to you, I don't want to go and see the other parent, then you are still making the child available, LW would suggest. But then since then, there was a later case of HB. It was a 2015 Court of Appeal decision, and the president of the family division at the time, Sir James Mumby, he took a different view on that. His lordship said, and if you look at paragraph 76 of the judgment, the president said that actually not just as a matter of parental obligation, but more as a matter of law, parents need to do more. To make available means to ensure in appropriate cases. If that means you have to persuade your children, you have to cajole them, you've got to blandish, you've got to confiscate. The classic one I can think of is taking a mobile phone off them, the iPad. I mean, you know what it's like, if the internet crashes for 5 minutes, all hell just breaks loose in the house, doesn't it? It's like the kids are thinking somebody's died, and therefore, if that's what it takes, if it takes for, the mother or father to say to the children, right, I'm going to switch the internet off, you're not going to, be able to go and play your games or whatever until you go and spend that, hour or so with your father or your mother and so forth, then if that's what it takes, the president said, that's what you need to be doing. And the other thing I would suggest sometimes is a nice little practical thing that I've done sometimes is you may want to use the use of section 11 subsection 7 of the Children Act, and that's a nice little bit that you can attach to section 8 orders, where you can attach conditions to your section 8s, such as, for example, the contact will be as follows: the parent shall, if needs be, in ensuring that contact takes place, do the following things. And if you put those extra elements to it, it makes it that much easier, I would suggest, to be able to enforce the order. So those are some of the things you might want to think about.
It's a good tip. We have at our Family Wizard, we have a draft order language that was written for us by Judge Dancy, taken from the Children Act, from that section, where we use similar language to stipulate to how they can best use those methods and techniques to go forward. So that is a really, really helpful tool. Saf, someone's just requested that. What was the name of that case you just mentioned with Sir Mumby?
Oh, okay, yeah. So that was the case of HB, so H-B. It was a 2015 decision, Court of Appeal decision. And when you do have a chance to look at it, if you look at paragraph 76, it's a bit sad when you can remember the paragraph numbers, but there you are.
You're the expert, Saf, so that's why we've got you here.
Okay.
The next question's come through is about parental alienation. I think we've touched a lot on that. So if there's time, maybe we'll come back to it at the end. But I'll move on to a different subject just while we're here. So the next question is, how does Practice Direction 36V operate in terms of family mediation?
Sure. Okay. So this is where we've got the position surrounding Practice Direction 36B. So this is in relation to MIAMs we're looking at in terms of the use of MIAMs, particularly in family cases. Mediation information assessment meetings, many of you will know. But also what's happened is just recently, earlier this year, in March this year, you've got now Practice Direction 36V, as you say, that has been brought into effect. This is a pilot which will continue until March next year, so 2022. And what it is this: if you've got, say, the parents who have either attended a MIAM, or there's a requirement for them to attend because they don't come under any of the exemptions, and so they've attended a MIAM or they need to, and there is a recommendation for them to engage in mediation. And of course, like anything, that will cost money unless they come within any of the exemptions. What PD 36V has done is there's a voucher scheme of £500. So basically, for those parents and families in that situation where the mediation is recommended and it's felt that it's necessary to go down that route, HMCTS have now provided a voucher scheme of £500 to pay towards that, so as to obviously assist in the costs. So it's two-pronged. It's one, to recommend and promote greater use of mediation, which of course in the right case always works, and it's a fantastic way of non-court dispute resolution. But secondly, and again tying in with COVID, which really affects everything we do nowadays, is because of court backlogs and delays, which sadly have increased as a result of COVID. It's a way of keeping less cases in court and therefore outside the court arena, which then deals with the backlogs. So having got spoken to some lawyers who've taken advantage of PD 36V, it works really well. And I hope that come March next year, they'll extend the pilot beyond that.
Definitely, and we work with so many mediators, and it's been fantastic to see that encouragement from the government and for people who are going through separation to know what the other options are. And actually, there's financial assistance to choose one of those non-court dispute resolutions. Everyone is telling us how backlogged the courts are and how few judges we have in family law. So anything that can help with those cases, as you said, it's for the right case, can really go a long way. Do you think there should be some sort of, not necessarily MIAM, but some sort of early evaluation? I know there's early neutral evaluations. Should there be some sort of universal meeting MIAM early neutral evaluation for all parents, so that when they are deciding to divorce or separate, they are given an education and exposure to what the various options are, including court, but as well as mediation, arbitration, all the various options? Do you think that would be helpful?
Very much so. I'm one of those lawyers. I'm very much in favour of non-court dispute resolution, and what I found is with MIAMs, even though it's a fantastic initiative that's been around now for 11 years, it's only limited, it's only required in cases where one is applying for what's called a relevant family law application. So it's a private children law, and if it's a financial remedy, so technically it doesn't apply to divorces, for example, it doesn't apply to abuse cases, albeit I appreciate in those cases it will be somewhat limited. But also the timing of it is always an issue, because sometimes the MIAM is something that's not considered until such time as the person is about to want to commence proceedings, and by then what you tend to find is the conflicts there, the unwillingness to want to compromise and work together is not quite there. So I think your suggestion, James, is a very, very valid one, and something that I very much recommend. The idea that really in any family dispute, albeit, except some of the urgent abuse cases, it's not going to work. But in many of the other cases, I would say that there should be almost this expectation to look at this early initiative from day one, from the moment, you actually meet your client. Absolutely.
Yeah, absolutely. And I know that the terminology around that is also being looked at. You say non-court dispute resolution. It was for a long time alternative dispute resolution, with the word alternative now coming with some query and issues, and it's language that the language project are looking at, I'm sure. But the terminology around that will be so important for the parents who don't know about this process when they are going through those proceedings for the first time. It can be daunting. So anything we can do to help is important there. We've had another live question come through here. Do you think the court should draw an inference if one parent refuses to use a communication tool such as Our Family Wizard? This happens frequently in very high conflict cases. It is intended to help. From an Our Family Wizard perspective, we do see that happening. The court has recommended or suggested they use Our Family Wizard. One parent is keen to use it, one is less so. Typically, the parent who's less keen to use Our Family Wizard is less keen to use it because they've realized that they can no longer get away with their old tricks. They can no longer have the advantages that they were having. It makes it an even, fair playing field. So that's typically why one may refuse to use it. We do have that order language, so the court can enforce it now through that language, or you as a practitioner can ask the parents to sign as agreement. But what do you think on that, Sapta? Do you think the court should draw on that at all?
I think certainly with Our Family Wizard, I think the tool and what it does, it's fantastic, absolutely amazing, it's really good. The difficulty I would foresee is if the court was being invited to raise an inference from that. Yes, in many cases it may be, and your experience, James, has demonstrated that in many cases it's because the parent who doesn't wish to engage in it is thinking, well, actually it's because I will be found out and I'm not going to be able to get up to those things that maybe I was doing. But then there will sometimes be situations where there could be other reasons. It might be that technology, it's not. So for example, again, going back to what we said earlier with remote hearings, we've got the Family Law Observatory who were asked to do several reports for the president. And one of the things they've highlighted and they continue to highlight is, even though remote hearings works brilliantly for professionals, for your average litigant in person out there, they want lawyers in court. They want us next to them in court and so forth. And I just think for some people, it may be that even though we've got these very sophisticated mechanisms down platforms which works brilliantly, for some it may not be. And I think if the court was then to raise an inference, it could maybe unfairly prejudice them. And because the welfare of a child is paramount, it's a bit like when we have findings made of domestic abuse. The cases of LV, M&H back in the year 2000 made it very clear that doesn't raise a presumption against contact. You've got to look at why did the abuse take place? What can we do to eliminate, to reduce, to avoid sabotaging the relationship? And I would really go the same way with this. I think raising an inference may be perhaps going a bit too far, but nonetheless, it's a factor I would suggest that is taken into account, and then looking at maybe their culpability.
Absolutely, and it's a conversation that we had between all those parties. With Our Family Wizard, we know that the tool isn't going to help every single individual, and that those cases are very relevant to their own scenarios. We'd like to help those that can help, but it's not for everyone, and that's the same with all these situations. So yes, it needs to be part of the conversation that is had relative to those parties. Looking at the time, we've probably got time for maybe one or two questions. So if anyone does have any burning questions to ask Safta, now is the chance to do so. Looking at the remainder of our pre-submitted questions, Safta, I'm going to ask you one which might be most suitable to close on here. And that's this: what are some of the proposed changes that we're going to see to the child arrangement program as provided for by the Private Law Working Party?
Okay, fantastic. Thank you. Yes, so that's the Private Law Working Party, who have been very busy working in private, I suppose, if that's the term to use, behind the scenes. It was several reports actually they put together over the last few years. There was one put together March and July last year, tied in with the harm report. It's been headed up by Mr. Justice Cobb, and what it's proposing, and some of the pilots are already beginning to take toll, is it's going to be revising the Practice Direction 12B, the CAP as we know it, the Child Arrangements Programme, there's a number of initiatives in it. And one, for example, which I just find amazing is this. We've all seen Room 101, haven't we, with Frank Skinner? So we all know about that. And as you know, when you've got guests on Room 101, they pick something, don't they? They'll say, oh, I want to pick the stuff that, this irritates me and I want to throw it into Room 101. The reason why I say that is because there's a new form that's going to come out, and it's going to be called Form 101. So that's the kind of correlation. Yeah. And this Form 101 that's going to come out, it's going to replace the Form C7. Now, the C7 is a form that, as a practitioner, it's one of those we fill in occasionally. It's the one where, say, I'm for mum, dad's apply for child arrangement, spending time with, otherwise having contact with, and mum's opposing. So we sometimes fill in a C7 to say, look, she opposes and that's her reasons. But the C7, it's a bit like an acknowledgement. It never really gives her enough scope for setting out her reasons. It's almost a bit of a formality. Well, this new Form 101 is going to be a much more extended version of that. It's going to enable her to put forward her reasons and even proposed directions that she may be professing to the court. So in that respect, I think what you're going to find in private law cases is you're going to have the issues between the two of them mooted a lot sooner. You're potentially going to have much more effective for HEDRA hearings. So unlike Room 101, where we normally bin stuff we don't want, I think that the Form 101 is actually going to be the reverse. I think it's going to be fantastic. So that's just one of several initiatives under the CAP program in that regard. So yeah.
And am I right in saying there's a public law working group as well?
That's right. So there was a public law working party report that was made available earlier this year. So the president of the Family Division, Sandra McFarlane, he in fact gave his approval to that back in March this year. So that came out earlier this year. So the private law one's taken a bit of a back seat for now, although, like I say, some of it is already being piloted. And the other big change that will come in is we're going to have a track system. So we're going to have what's called a fast track and a kind of almost a multi-track. So that, say I'm for dad, he's got benefit of an order which, say, the other parent is not complying with. Rather than taking it back as a rerun of contact, he'll be able to go under the so-called fast track procedure, which I'm hoping will mean judicial continuity, sooner hearings, and resolution much earlier. So we're almost going to have a track system in private law, which I think is fantastic. That would help tremendously.
That sounds like a streamlined system is important there. Wonderful. Look, well, we've got to wrap up, unfortunately, Safta. That's all we've got time for today. I know there were a couple of pre-submitted questions that didn't get asked. So if you do want to know more information, if there's anything else, please do reach out to the solicitors group. But thank you ever so much to everyone for attending the LAW2021 Online Family Law Shape the Debate, hosted by our family wizard. Thank you ever so much to the wonderful Safta Mahmood. You'll see more of Safta and I next year online and hopefully in person as well, if all goes well. Don't forget to join the solicitors group LAW2021 Online community on LinkedIn to continue the debate after the live session and to be included in exclusive offers for future events. As I mentioned at the beginning, a recording of today's live Q&A will be sent out by email within the next few days. And there is still time to watch the pre-recorded content. Your expiry date will be displayed next to the webinar. And there is still time to buy the complete event, including a recording of this live session if you haven't already. To book, just go to www.thesolicitorsgroup.co.uk, where you will also be able to find the online exhibition. The online exhibition is open to anyone to visit, and if you have booked the entire event, you can claim your 1-hour free CPD webinar from the webinar learning catalogue worth £35 plus VAT. If you can also visit the Our Family Wizard exhibitor page, information while you're there, that would be fantastic. Finally, feedback forms for the event will be sent out when the event closes. By completing this, you will receive your CPD certificate. That's it from us. Thank you again. Have a lovely day and have a very nice Christmas when it comes around to you all. Thank you again, Safta.
Thank you very much.
Yes,
Thank you. Bye, everybody. Bye for now.